Thanks, Dave.
Good to go.
Okay. Good morning. This is a convening of Massachusetts Gaming Commission. We're holding this meeting virtually, so I'll do our roll call. Good morning, Commissioner. Good morning, Commissioner O'Brien. I looked at the time because we've already met for our agenda setting meeting, and I apologize to the public.
Still morning.
Thank you.
Good morning again.
Thanks, Commissioner. Commissioner Hill.
Good morning, I'm here.
Commissioner Skinner.
Good morning.
And Commissioner Maynard.
Good morning.
So we'll get started with our public meeting number 475. It is still August 30th on a Wednesday. And as I said, we started our work day with an agenda setting meeting at 10, very productive. And now we'll turn to a public meeting that's focused on just a couple of items today. Commissioner Maynard, you've got some minutes for us.
Yes, Madam Chair, and we actually rolled these over, so I appreciate that. We found a small typo and it actually dealt with Commissioner Skinner, so I wanted to make sure she was here. Madam Chair, I move that the Commission approve the minutes from the February 2nd, 2023 public meeting that's included in the Commissioner's packet, subject to any necessary corrections for typographical errors or other non-material matters.
Second, Commissioner Maynard, and thank you for the courtesy. And you'll be happy to know I also caught that typo. So.
Okay, we have a second. Okay, Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
I vote yes. Well done. Thank you to the team for the minutes, and thank you, Commissioner Maynard. All right. So now we're going to go to any administrative update from you, our interim executive director, and of course, General Counsel Grossman.
Thank you. Good morning, Madam Chair, Commissioners, and all who are joining. Just really briefly, I wanted to just share one piece of information. Since we'll be looking at amendments to the application for a new racing meeting operation shortly, I thought I'd take just a moment to update you on a related matter. Yesterday, we met with representatives from a group known as Bay State Racing. This group is in the process of coordinating a proposal for a new track to be located in the city of Gardner, Massachusetts, which, as you may know, is not too far from Fitchburg and Leominster. Their interest and intentions have not only been publicly reported, but they've submitted a public comment on the application, which we'll be taking a look at. So this is certainly not breaking news, but it was helpful to hear from them directly, just to help gain an understanding of their timeline and some of their early thinking. They're keenly aware of the need to secure municipal approval prior to submitting an application to the Commission. And based upon this and perhaps a few other matters, it does not appear at this juncture as though an application will be submitted by the October 1st deadline by this group. That said, it is possible that there are others out there who might have an interest in pursuing such a license. So our work today remains timely. And further, just as part of this process, as we've discussed in the past, I just wanted to note that there are a set of regulations governing the racing licensing process that are being developed by the team and should be available for Commission review shortly. That's where many of the customary provisions related to completeness and financing and suitability and things along those lines will be expressly addressed and set out by the Commission. So that's coming soon. With that, we can, I'll pause for any questions you may have, but I just wanted to mention that as part of the update.
Commissioners, any questions for Councilor Grossman, Executive Director Grossman? Okay, thank you. Anything else, Todd?
No, I think we're ready to move on.
To tackle today's agenda. Okay. Thanks for bearing with me. My screen just went dark. So we'll turn then right to Dr. Lightbound, which was my memory. So Dr. Lightbound, we are now going to work, I assume, with the, I think I've seen Counselor Young.
Ms. Young is unable to join this morning. Ms. Monahan and I will pinch hit for her along with Dr. Lightbound.
Okay, so Counselor Monahan, Counselor Grossman will join in, and Dr. Lightbound will have you lead. Thank you.
Thank you. As the commission knows, the form was brought up before the commission earlier, and then it was put out to public comment. I'm going to briefly discuss a few of the public comments, and then I'll turn it over to the legal team to discuss some of the other public comments. We received several comments regarding that the 100 days of racing that is required for simulcasting would be potentially too much for a new track, and the legislation has been changed, going into effect on August 10th of 2023. The legislature changed it to a requirement of 20 days, and then it also leaves it up to the Gaming Commission to decide if it would be less days. So there is that flexibility there now, and obviously if a applicant did apply, the commission could, that would come under discussion. So I want to ease everybody's minds that made those comments that the commission is aware of the possible need to discuss the number of days that would be reasonable for the beginning of a new track. Another comment we got was regarding the ability to train the horses. As you know, they just don't show up to race. They also need to be able to train up to it. And that would certainly also come up in section 2, the project summary and financing. There's numerous places that would come up, planned accommodations, amenities and facilities and services to be offered. Section 210, the feasibility and economic impact. Those could all be, would include the possibility of training. And even in section 6, the public interest, why the project is beneficial to the public at large, the Commonwealth, the applicant, and racing stakeholders. So certainly that topic is also would be addressed in the application. We did get, as Todd mentioned in his administrative update, we did get comments from Kevin Conroy representing Bay State Racing, and then we also got comments from Barbara Kellogg. And I'll turn it over to Caitlin or Todd if they want to elaborate on those comments.
Sure. So one of the additions to the application, or I should say potentially clarifications to the application, relates to the applicant needing to receive all necessary final approvals in accordance with General Law, Chapter 128A, Section 13A. And as you all know, that is sort of the local approval, the town council or board of selectmen approving the location of the racetrack. So the way that this is worded is intentionally does not have a specific deadline for when the approvals need to be submitted or voted on. And I'll explain why in a minute. And it basically says in order for an approval, so there needs to be a final approval before submitting an application. And then it goes on to state that in order for an approval to be deemed final, there must have been an opportunity for the petitions or special elections set out in Section 13A to be in place, and any such petitions or special elections must be complete. The reason why there isn't a specific number of days, the approvals have to be done 30 days before the application comes in, is because the statute does not set out a deadline for when the citizens of a town can petition to basically have their board of select people's approval overturned. And because of that, it's up to the town to make that decision as to sort of how long the citizenry has to submit that petition. There is a separate statute, not the racing statute, that sets a 20-day standard for cities. So the citizens of a city would have 20 days to submit their petition, but that does not apply to towns. And so because of that, we believe that it is on the applicant to come to the commission with evidence that the process is done, the required approval has been received, there's been time for the citizens to petition, and that petition hasn't happened. And so, and we don't have the authority to sort of set a deadline for that, for when that petition has to be in. So with that, I'll pause and take any questions.
Questions, commissioners? So Caitlin, could you just, in terms of what Mr. Conroy is asking for, how does
So
that?
he's asking to say that the petition, that any citizenry has 20 days to submit its petition to sort of overturn the approval of the Board of Select People or the town council. And I think from our perspective, that is not set out in statute, and that is not something that we have the authority to require. So there's not a deadline. It's going to be on the applicant to prove that they basically got their approval with enough time for the rest of the processes to play out.
There is certainty in each, and so each town or city has some varying appeal or petition process, or is that what it is? Is there, I guess I'm just wondering, is there a degree of certainty for our purposes too, never mind the applicants? Yeah.
So for towns, there's more certainty because, I'm sorry, apologies. For cities, there's more certainty because, again, there is a separate statute that sets out the 20-day requirement. For towns, I think it would be on the local council for that town to say whether or not enough time has elapsed or whether there's a specific provision for that town that would apply. Obviously, we can't know, the bylaws of every town.
That's right.
So again, it's on sort of the applicant and the town to work together to determine whether that period has passed. And, there could always be a situation, because there's not a specific deadline, where citizenry comes in at a later date and says, hey, it's a year later, but we still want to petition. That might have to go to court at some point, but that, that's not, again, not for us to say.
If it is silent though, what is the solve?
Again, I think you'd have to look at it town by town. Yeah, town, not city. I'm mixing up my cities and my towns.
No, I understand. It's the city has more certainty. But if the town is silent, we're not giving. What you're saying is you're suggesting that we can't give any recommended timeline because theoretically that's open forever.
Theoretically, the people of the town could come in 20 days, 30 days, 40 days, 50 days, however long it takes them to get their petition together and in. At a certain, if you're at a point where, hypothetically, an applicant has applied in a town, let's say they got their approval 90 days before the application comes in, the commission, the applicant, it would be on the applicant to say, we put this in, we're representing to you that we haven't heard any rumblings that there's going to be a petition. The town could weigh in if it needs to, and the commission would have to make a decision as to whether it's complete or not at that point, understanding that if the citizenry moved forward at 120 days, and it was accepted by the town and there was an overturning, then that means that the application could have to be, or if there was approval, the approval might have to be revoked. It's not great, but I think it's the best we can do at this point. And hopefully, the goal is that the applicant knows, get your approval with enough time that the citizenry would have had, a reasonable amount of time to sort of get their petition in. Don't do it 10 days in advance of the application deadline.
Commissioner Skinner.
Caitlin, I understand what you're saying. I think that's the ideal way to do it, is to provide for the applicant to provide as much lead time as possible to account for those uncertainties. And I understand why we would not make the adjustment in adding the time frame to our application. But that process that you just semi-described, where an application has been submitted, they have the approval of the town, but then there's just this remaining question as to what the time frame is for the citizens to ratify or not to approve or deny, however the
Well, to-
referendum.
to submit a petition, apologies for,
Submit the petition, and
Yeah,
so, I think I'd be okay with sort of allowing for that kind of a contingency, and so what would that look like? And do we need to, make any determinations now relative to that potential scenario?
I don't think so. I think it's going to have to be application by application. Unfortunately, for towns, the commission is just going to have to decide, again, has the applicant submitted information that the commission feels comfortable with moving forward with the approval as it currently stands? Recognizing that, if by some chance a petition came in very late in the game, it was accepted and the decision was overturned, that the applicant couldn't move forward. But again, we're trying to avoid that. We're trying to do this all well enough in advance so the people of the town can raise their hands and say, we're working on a petition. We're going to get it in by this date. Or
Yeah.
actually get it in.
But presumably, as you alluded to earlier, we'd be relying heavily on guidance from the town in terms of how they see their deadlines shaping up in connection with that particular issue.
I think that's right.
Okay, thank you.
All right. Any other questions on the final approval? Okay, then we can move to the comments of Mrs. Kellogg, which I believe they start.
Just to be clear, did we go through all of Mr. Conroy's?
I believe that was his only.
Likewise, state clear that if petition is filed within 20 days then the commission will not find 13A approval to be final. That second to last paragraph, I don't know. Do we need to add any clarity around that?
I would suggest that our proposed revisions to the application are clear enough, but again, happy to take comments, thoughts on that.
Yeah, well, maybe we can just look at that particular section and just make sure. Okay, I'm good, thanks. Now, Ms. Callens.
Yes, and I'm trying to find I think that's page 21 of your packet. So Ms. Kellogg, as you'll remember, actually submitted comments on the last version of this, many of which we took, and she notes that in her letter. So she has come back with a couple of other proposed amendments here. So the first one is that starting on page 22, she believes that engineering plans showing the needed grading as well as the composition, shape, and size of the track must be an exhibit. So we do have a provision in the application that requires sort of information about what the track is going to look like. And of course, there's a statutory requirement that the track be a mile. I think it's up, again, it's up to the applicant to provide information sufficient for the commission to make a determination as to whether this track is appropriate and meet all the requirements. I'm not sure that we need to get into the specifics of exactly what they need to present in one reason of which is, of course, I wouldn't want to miss something and then have them say, well, it wasn't specific enough. So I think, again, for applicants, the more detail, often the better. And that's what I would say with regard to that comment. Any thoughts or questions?
Madam Chair.
Yes.
So under the application and under our regulations, we could ask for that information if we felt we needed to. Is that accurate? Under the way
Absolutely.
it's written? Yeah.
So if you get an application and you decide you don't have the information you need about the track, you can absolutely ask for more.
Dr. Lightbaum and I have been, discussing how racetracks work and the different types of tracks that are now available, and I can assure you and fellow commissioners and the public that how a racetrack is going to be built and safety of horses and things of that sort are going to be paramount in anything that I would ever look at. And I think the regulations give us the ability to ask for more information if needed, I think.
And
So
Commissioner Hill, we've got a good track record, not to use a pun, but on on making sure that the integrity of the track Plain Ridge is state of the art. Dr. Lightbound should be credited for that good work. So I agree with you. I bet all of us are in agreement that's going to be a priority, and we've got some good background on it. Dr. Lightbound, I don't know if you want to expand on that at all, but.
Yeah, so, and like Commissioner Hill said, we've been exchanging, news reports and all on some of the topics that have been going on. And there is definitely movement towards safer racetrack surfaces. And we've, any new application is going to have to meet the federal legislation that's gone to in effect if it's a thoroughbred track. So there's a whole slew of safety recommendations on the track surface and all that, as well as the medication and the veterinary world as well. So that would all go into effect, which is something that we haven't had before in Massachusetts on the thoroughbred side.
I know,
And-
Commissioner Hill, you come from, I know your mother was such an animals advocate. So you told me first thing that this would always be a priority, and it has been.
And will continue to be. I actually, Dr. Lightbaum just brought something up that I just want to make sure language is in the application. We now are dealing with federal regulations and federal law. Do we have language in there that says you have to adhere to all the federal laws? And I know we do state laws, I know we do regulations state, but I just want to make sure that in the final copy, there's language that they also have to adhere to the federal guidelines that have now been put into place that weren't there a few years ago.
I know there's an attestation at the end that says you have to abide by all. I will make sure that it includes federal.
It does. It's in.
Oh, great.
Thank you.
Okay, great. So moving on, a couple other specific requests with regard to the application. One was adding requirements, an independent traffic study. So we do actually require a traffic study now. That was one of the changes that was made. So I think that is covered. An actual parking plan for horse trailers and workers and patrons on site. I'm going to go through the next couple together. Details of on-site water and sewer and other utilities. Again, I would say we ask for a lot of detail. We could certainly add those provisions, but I think we do ask for a lot of detail. And again, we can always come back with more if we need to, but every plan is going to differ a little bit, and some of that might be pretty detailed for the application. But happy to take comments.
May I suggest that we put language in IE and then list a few things?
Sure.
I don't know if my fellow commissioners feel that way, but if you give examples of things that we would like to have, I think that's always helpful.
Perfect. We can do that.
As long as we make sure that it's clear that it's not limited to those examples. Yeah, I agree.
Great.
Can you just, I just want to make sure we're all looking at the same. Are we now looking at a precise section in the application? Or are we just talking globally?
I think these comments, she says they're related to section 2.2, but I think we could find the appropriate, section to put in those examples.
Yeah.
And then, Mrs. Kelly suggests a couple of different studies, including an economic impact study, and, basically a study on, I think she has a study on the evidence and availability of thoroughbreds to actually race at the proposed location. With regard to the first, the economic impact, I think we do seek out information about the economic viability of the application. So I think, again, that can be part of it, and that is part of it, I would say. With regard to, and I'm skipping a paragraph here, but with regard to the study and evidence of the availability of thoroughbreds, again, I think that goes to the question of, can they race, and, are they going to have horses to race? Are they going to be able to make this a viable operation? I do think that's included without requiring sort of a specific study about the evidence of availability of thoroughbreds. That seems like potentially a lot to ask for, again, in an application. Any questions or comments on that section? And then the last comment relates to sort of, we do now ask for all information about any host community agreements, agreements with folks in the town. And I do believe actually that was at the suggestion of Mrs. Kellogg last year. I think she's now suggesting that the host community agreements must be negotiated and signed prior to the local approval. You know, I think I would leave that to the towns to make a decision as to when they want to get their approvals by. Certainly, if the town didn't feel as if it was being listened to or heard by the applicant, they could come and comment on that. There is a statutorily required comment session and their voice can be heard. But I'm not sure that I would require that the host community agreements happen before the ones who need approval. But again, we can make any changes we'd like on this. All right, so I think that is it for the comments specifically related to the application.
Caitlin, could, on the track quality, back to Commissioner Hill's point that it's of paramount concern for us, there, to the extent there are different services being offered, does our, and forgive me for not being able to point at a particular section, does our application, or should our application ask for experience in installation of tracks and the type of tracks, anything about that, given the safety issues that are arising? Do we have it where?
I don't think we have that.
Probably going to be hiring, someone to install it, but I just wonder if we want to have any controls over that selection process and experience of the vendor who would be doing work.
Apologies, would that be more for the reg than the application?
I don't know.
We can certainly take that back and figure out the appropriate place for that to make sure that whatever vendor is actually putting in the track is, experienced and accredited to whatever extent there's accreditation.
Yeah, Dr. Lightbound, maybe there is a certification process for that you know about, and I don't know. Do you feel that the application addresses that sufficiently?
We did strengthen some wording in the application about wanting more detail on the track itself, and certainly the commission could ask for it. And
that's in that red line 2.3 subsection A, and detailed description of track, including description of racing surface. That's your, okay. Anything that we want to add to that, commissioners? What do you think, Dr. Lightbound? Should we add something about experience, or do you know, are there just a few certified track installers, or is
Yep. So one of the things that they would have to do is meet the HISA, the federal legislation, and they do a certification of the racetracks now. When Suffolk was racing, that certification was done under NTRA, and Suffolk had that accreditation, and they had to renew it every 2 years. So, in Massachusetts, we're used to having to meet those requirements. Now that has moved over to the HISA, the federal legislation, and they would be the ones who would come in and certify, and they have the experts on staff that would do it. Yep.
Thank you. Really helpful. Thank you. Okay. And if I missed that earlier, my apologies. Okay.
So, I just muted myself. That's everything we have with regard to comments and modifications to the application, but happy to take any questions more generally.
Questions on the comments? And Caitlin, are you going to, and Dr. Lightbound, are you going to walk us through the license one more time before we vote on it?
If I'm being totally honest, I was not prepared to do that. Pinch hitting a little bit today, but I'm not sure if, there's Judy.
Hi, commissioners. Thank you for your patience. And also, Caitlin, thank you for pinch hitting for me. I am just kind of getting everything up in front of me, but I'm happy to walk you through the updated application if you'd like to see everything soup to nuts.
Well, the red lines, and then if there are any questions that commissioners have thought of, particularly given comment
Sure.
before we vote on this or experience in between. Okay.
Certainly. All right. So starting, good morning. So starting on page 21 of your meeting packet, I'm just going to walk you through the application again. So starting in the beginning, we have kind of the name of the applicant and the general information that would be seeking, where they intend to conduct their racing meeting, the calendar year in which they intend to race. As I noted the last time we walked through the reg, this is the 2024 racing regulation, even though we will have somebody actually submit this application October 1st of 2023, but they will begin a racing season in 2024. So it's always the year after. Next after that, we get into section 1. As stated in the memo, this section is not or has not been changed. That's why there's no red lines within it. Aside from a few formatting changes and additional spaces, an applicant would have to go through and list this general information, mailing address, principal office, and also I think we asked them to provide a contact information for their lead attorney. So that section 1.9 was added in last year, but otherwise this section is fairly similar to all previous racing applications issued by the commission. Moving on to page 23 of your packets, we keep going through the tail end question of section 1, and then also beginning section 2. There is kind of a note, commissioners, that we do recommend the applicant kind of take notice of, in which case we set out the requirements listed in 128A section 3I, and that the commission in reviewing this application will take into consideration these and any other appropriate or pertinent factors, and then a large laundry list, if you'll excuse the expression, of the factors and considerations that are set forth within this application. I would also note that 128A section 2 allows the commission broad discretion to consider other factors as well when offering up and evaluating an applicant for licensure. So moving into section 2, the largest red line change is what was kind of recently raised by the commenter, Mrs. Kellogg, and explained by Dr. Lightbound in section 2.3. We've strengthened the language asking for the applicant to provide as much information as possible in regards to the size of the track, and requested a detailed description of the track, including a description of the racing surface. So, Madam Chair, as I was kind of just getting up to speed, we could strengthen that language a bit more to, include some mention in terms of an installation plan or the additional details that a licensee or an applicant at this point would have. However, it is somewhat early when a person would submit this and the track may not be constructed. So another option, or something that the commission could also do, was condition licensure upon subsequent demonstration of an adequate racetrack. That was kind of in accordance with the standards that Dr. Lightbound enumerated by the HISA, excuse me.
So that certification, that federal certification, they have to have that in place before they can race, right, Dr. Lightbound?
Yes.
Yes.
So I'm just taking a note right there.
Commissioners, I guess that helps on clarity, but it is a given. They can't, there's no discretion on our part to waive that or anything. Got it. Excellent. Thank you, Trudy, very helpful. I just call you Trudy.
It's okay.
We do it all the time. I think I get called Judy because of Judd, and she gets called Judy. Sorry. Thank you, Judy.
4 kids in my family, so I've grown up always being called a different child's name. Sometimes I get the cat. It's all good.
I'm two sisters, and my mother raised 3 Judys, so there we go.
All good.
Thank you.
Okay, so moving
As I like
on.
to say, Madam Chair, I've been called worse.
Yes,
Yeah.
that's the one. All right, so moving on, that is the only substantive change within section, within section 2 of the racing application. Moving on into section 3, there were also no substantive changes in this section. This section asks for the schedule of proposed races and also sets out whether or not the applicant intends to race in calendar year 2024. So that change you won't see in red line, but it's kind of an obvious that we update the year every single year in the application. And then we've also asked them if they don't or do not intend to race in the calendar year they've submitted this application, what calendar year that they intend to propose or conduct racing meetings. So moving on next into section 4. This section has been reworked from the last time we brought this application to the commission in July. Going off of the concerns raised by the commissioners, we have added an additional question in section 4.2, but also strengthened the language in question 4.1 to make it very known to an applicant that they need to complete all of the approvals, and requirements enumerated in section 13A of chapter 128. So in order for an approval to be deemed final by the commission, there must have been an opportunity for the municipality where racing is going to be located, or in the city, for the citizens of that city to have had an opportunity to approve or ratify the finding by the municipality or by the city, and having some kind of a vote. So the reason that we wanted to do that is that it really does, there is a specific timing to when a person can receive an approval by either a select board or a city official or a municipality, And so it just kind of contemplates the full process that an applicant would need to also make sure that that approval was ratified as set out in 13A. And I can discuss this a bit more, commissioners, if you have questions, or we can keep going. Okay. Moving on into, question 4.2, we also asked the applicant if there have been any votes as categorized within 13A, so that, again, that petition that could be initialized by 12.5% of voters within 13A, and then triggering a 45-day special election window, or any other votes taken concerning this proposed project. This question is kind of to elicit that information out straightforward, and also to be able to demonstrate whether or not this person has given sufficient time for that process that's captured in 13A to have actually happened. Questions on that new question, commissioners? Okay, fabulous. All right, moving back through, we have also added one more question on page 27 of your meeting packets within section 4. We've asked an applicant or a potential licensee to describe and submit as an exhibit any sort of support or opposition to the proposed project expressed by the surrounding community, governing body, any government officials of the host and surrounding nearby communities, and also evidence of support or opposition in writing. This question is intended to prompt and promote an applicant to really be as transparent as possible with the commission, but also to, be mindful of its surrounding community that it intends to launch this track and this business within. I should say that this question is also largely borrowed from the public interest section of this application in section 6, but we wanted to move it up in regards to the municipal vote and these required commission approvals. So that's why you'll see this question here as well. Any additional questions, commissioners, on section 4 before we keep going through the application? Okay. Section 5 on qualifiers and suitability. I will say that this section is the same from when we walked through it earlier in July. I will note that this section does have mention that a qualifier can request to be withdrawn. from consideration as being a qualifier status that is similar to what you see on the racing and sports wagering side.
Given our most recent meeting on suitability, right now, the only guidance that we have on suitability is this application because we don't have the regulations, correct, on the process.
That is correct, Madam Chair. So we, on the racing side, we are working on our regulations, and I hope that we can have them disseminated internally and then have a meeting on them shortly. But there is a section within the racing framework that sets out the requirements of both preliminary suitability and durable findings of suitability performed by the IAB and Commission.
But then that's a suggestion that it would fall under 23N versus 23K approach. So we'd be seeking certifications. Is that how we're doing this here?
It's initially how it's contemplated. However, I think, and forgive me if I'm speaking out of turn, Todd, what we wanted to do was kind of present an option to the commissioners that would kind of mirror the preliminary and durable findings that's presented within 23N. Instead of the 23K, but if, in walking through it and kind of presenting it to the commissioners at a public meeting, the alternative situation that's presented or contemplated within 23K seemed more amendable to commissioners. We could take that feedback back and kind of alter the regulation, or at least that section, while having the other sections of the regulation go forward through the promulgation process.
I would just supplement that just by adding that the reason that was contemplated, you'll recall, is that the commission by statute has to make a decision on an application by November 15th upon an application submitted by October 1st. So the reason that'll be proposed is just to recognize that and the understanding that a full suitability investigation and proceedings on that may take longer than that 6-week timeframe.
Commissioners, how do you feel about the fact that we don't have our regs in place, but we'd be voting on the application? I'm just thinking out loud. I don't have an opinion. We have to get this application out. Sorry, Commissioner Hill.
Madam Chair, I have no problem moving forward with the application before the regulations come before us.
I'm thinking practically here is that if we want this out for consumption and use, I don't see how we do it any other way.
We'll note that the prior to our draft regulations, which will come before the commission shortly, there is sufficient precedent there that's enumerated within the introduction to section 5 on page 27 of your packets that we have relied on before to kind of clarify to potential applicants, that the commission does consider the interests of the public in racing competitions honestly managed, in which case we, have in a different way contemplated suitability and the approved practices of racing. But I think in this case, what we'd like to do is to, have a framework within regulations similar to what's contemplated and performed by the commission within the within the sports wagering and gaming frameworks as well. Any questions on section 5, commissioners, or?
No, just to throw my thoughts out there too, that I think I'm comfortable moving forward with the app as written, knowing that the regs are coming soon after. I'm okay with that.
Okay.
And the basis of our authority is strictly in that case, correct, Todd? And
As well, so yes, there's the case, and then there's actually the language in 128A that talks about, and this is on the application too, that the commission must consider the interest of members of the public in racing competition honestly managed. So between the two of them, we've proposed this approach.
Can we make clear that an applicant could seek, and we use the word waiver, withdrawal at any time? Make it clear that,
There is a provision on the top of page 28, Madam Chair, and it is a portion of question 5.1 that just got knocked down. It reads, an applicant may seek waiver for any person on the above list who lacks the ability to control the activities of the applicant. So we
yes,
could, if
yeah,
we're
that's
interested
what
in
I'm
that,
reading
add
from.
at any time.
Well, I think I'd like to be able to hear if somebody, if we have an applicant who, IEB, I guess it's IEB, is that who's determining the, who's a qualifier? Have we figured that out? Or do we have
It
to
says,
determine?
so within question 5.1 subsection 5, it lists the division of licensing after consultation with the IEB. So it's a similar protocol that's enumerated within the sports wagering regulations as well.
Yeah, that's one of the factors. So I'm assuming that it's licensure then all the way through that determines all 1 through 5. And then,
Correct.
and then I guess given the recent experience, I guess I'd like to make sure that we qualify that an applicant could come to us and request a withdrawal from their qualifier. And we would respond to that timely fashion.
Is it the same? Should we use the same language though? Isn't it what moved to be? What's the language that's currently used?
Let me grab it.
De-designated, I think, right? Wasn't that the
No.
phrase that we used?
No, I think that's a notice of withdrawal. They have to file a notice of withdrawal. And that they could, I think there's language about time that they can do it at any time.
Chair, just really quickly, I think this would be something that the IEB would want to be in close communication with legal with respect to the way the reg is drafted.
Absolutely.
You know, at what juncture it's the IEB's decision to de-designate versus when it would have to go to the commission.
Well, I guess I'm wondering the whole process is, is this an IEB driven process because we're adopting a regulation? I don't know. I assume that's right, Heather. But I guess I'm just wondering on that particular language. I think it was withdrawal. The regs use the term a notice of withdrawal, if I remember correctly. And I think that reg that did have a time factor in it. I don't have it in front of me.
I'll defer to legal to correct me if I'm wrong there, but my recollection of 213, and you know, obviously this isn't the specific reg we're talking about at the moment, but is that the IEB would be able to de-designate based on its own decision. But if it was before the commission, if there had been a meeting for the commission to review the application, then it would ultimately be the commission's decision. That's my recollection of the provisions of 213.
The way it worked is that there was a couple of requests on the last one, and those were denied. And then there was a time factor as to when they could come before the commission. I'm hearing you make that suggestion as how you'd like it to follow here. I don't remember where it was where it came to the commission, but there was a little, I know I received a question from a fellow commissioner about that particular issue. You know, noting some confusion around the timing of the inquiry. So I guess we want to just clarify that. That's really what I'm getting at. When can and the applicant here for horse racing ask to de-designate, give, you know, withdrawals, hoping we don't have to go through it. You know, that but because it's so fresh in mind, it might as well tackle it if we can for clarity.
Completely agreed. Sorry, Caitlin. I was just going to add that I think, we can use the regulations that are forthcoming as the vehicle to address this as opposed to the application. It'll obviously take a lot of careful thought as to how that process should unfold. It has been modeled after the existing language in the regs, but in this context, we need not necessarily follow that. We can make any adjustments that might work better in this racing context as well. So I think for purposes of this application, the fact that it's just identified is helpful. And then we'll maybe drill down much further when we get into the regulations.
And commissioners, I don't know if because we went through this application before, if we're all comfortable that this is the standard, that this is the approach we want to take, and it being following 23N. I just want to make is that a consensus, or do we need to talk about that? Because I'm not sure if it was really.
Yeah, the commission has never weighed in on that. I think, and I don't think that it's not necessarily reflected here in the application itself. We were just kind of giving you some context and texture. The way I view the application, if this is helpful, is just that this is the vehicle by which we gather all the information that the commission will want to consider in rendering a final decision. But it's the regulations that will provide you kind of the infrastructure to make the decision and set out the standards and things along those lines. So this, I think, puts the applicants on general notice as to what the commission will be looking at. And of course, there is some jurisprudence referenced and some provisions of Chapter 128A, but we'll provide a lot more structure in the regulations and things. I agree completely. The things like whether the commission wants to adopt a preliminary suitability model or not, and who will do the investigations and things along those lines are all on the table for consideration by the commission, because none of it is set out in Chapter 128A.
So I'm just going to note that if I were an applicant, what we're saying is we want them to deliver all this information to us, but we don't really know. We haven't made a decision as to the process. And I'm thinking of back when we developed the sports wagering application, Commissioner Maynard, you worked really closely with the team on this. If we had the regulation structured, so I'm a little bit, I get where we're going and I get the practicality. And I think I even said that maybe that reg wasn't in place. The application reg wasn't in place when we put out the application, but
I'm sitting here thinking, well, I would say it this way. I can't remember exactly if the application reg was finished or not, but there were a lot of regs that were implicated in the sports wagering application that I'm sure were still being finalized. That would have, to Todd's point earlier, kind of would have ultimately affected that. So I'm thinking of the alternative. The alternative is the regs and the application aren't up by the end of the deadline. So I'm just trying to square that up.
I know.
That's exactly right. I think just to be clear, we are putting the cart before the horse. There's no question about it, but it's a practical consideration. And that's why we're doing, or we propose that it be done.
And for me, Madam Chair and Commissioners, the alternative that Commissioner Maynard just kind of alluded to is just not viable, right? I mean, and as to whether we use 23N as a guide for reviewing suitability or 23K or something else, is still up for discussion. But I think when Council Grossman referenced the deadlines that we're up against, I think 23N, the 23N structure is not a bad idea.
Commissioners, have you walked through all all of section 5 and all the questions that are asked? Because we haven't really gone through those with a fine tooth comb. So just so that you know what everybody's going to be asked to give. Is everybody comfortable?
Is it accurate that most of this section is based on the BED, some of these questions?
And I guess I also wonder, is it disqualifier, if we're reviewing this as an application, if they say something that we expect a yes to and they give us a no, I'm hearing Councillor Hall say it's an IEB decision-making, but it's an application that's coming for us with particular questions. So it's a little bit different altogether. Do you see what I mean? And Todd, you and I kind of touched on that. It's different, you know? We're going to get the application in front of us. So, for instance, has an applicant in any of us ever had a financial or other interest in a racetrack? And they would submit. So the application, we will be looking at suitability in a different way than I think per this application than what we've done with respect to 23N or 23K. And I'm speaking in real time because this has been a work of art, and Judy, you've worked really, really hard on. So I just want to make sure that we're all comfortable with, let's just say, I'm just always imagining that we might have an applicant who delivers. So if we're comfortable with the application and how it is written without knowing the process, we do have to have it ready for October 1st. That's right.
And I submit that it actually should be way before October 1st if possible. The deadline to submit it is October.
That's right.
Madam Chair?
Yes. Help me out, Commissioner Skinner, maybe.
Well, I think I need a bit of help. I'm trying to understand your concerns. This is an application for a new
Yes.
racetrack,
Yeah.
which the commission has released annually. Correct? And we are now proposing changes to it. And so what is different this year than the other years? Because we have not had regulations thus far. So just, I'm trying to tie the knots, to close the loop here. I'm just trying to understand what your concern is this year that might not have been a concern for you in prior years.
Did we have the suitability section in the past, Councilor Grossman?
I believe it was in the last version. And just to kind of refine, Commissioner Skinner, your point, this application is of a more recent vintage, although it has been in the past couple of years out there, but it hasn't been out there for 10 years or anything like that. It's just the past 1 or 2 years. The amendments and updates, if you will, were derived based on our experience and having handled an application that came through recently, and some of the public comments that have come through, and just our experience in general overseeing horse racing. So it's been refined based upon those areas. And we're finally getting to a point where I think the process is actually really taking shape and coming together really well. But for a variety of circumstances, we haven't been able to get the regulations done first. That would certainly have been ideal. There's no question about it. But this is, I think, a workable plan as well. I think, to your point, Madam Chair, there are certainly some questions on the application that maybe after the process is set out, you will say need to be adjusted or refined or even scrapped if it's not relevant. But for purposes of today, I think we felt like this, again, is just a good vehicle to gather what we believe will be the relevant information so the commission can make an informed judgment.
And the only thing I would add to that is just for clarification, and Judy can tell me if I'm wrong, the changes to the application that are new, that weren't in last year's application are only the items in red. So it's actually sort of a relatively small set of changes to what was last year's application.
So Madam Chair, I want to understand your concerns. I'm not minimizing them at all. I just, if they're, I think we all can agree that the ideal way to do this is to have the regulations first and go from there in terms of making adjustments to the application. But I want to, my responsibility, I want to understand whether I should be paying more attention to this than I am currently under the circumstances.
Yeah, so I think this, when was the last time this was voted on? Was this last fall? Like, so the red line is compared to what? Compared to the last vote was when? I guess what I'm trying to get, like, was this last November?
The last time,
these are red lines to that? Like, where are we?
yes, great question. So the last time that this regulation, or I'm sorry, this application was before the commission was June 1st, 2022. So everything in black was voted on the commission June 2022. The application was posted online and was available. Folks submitted information according to that, and then we've taken it down since then and then made edits that are all appearing in red line. And then, brought this to the commission last July, and then ultimately made a few more changes that are like still there in red line. So anything not in red line is a part of the previous 2022 application voted on by the commission.
And then the vote we had last November was the reg. Is that what I'm remembering?
That's correct. That actually was December 1st, 2022.
Okay.
Which reg?
No, there was something last fall, I thought.
So that was when the regulation initially came forward so it was draft 205 CMR 2.01 that enumerated the sections of the racing application. It went through the promulgation process. There was a hearing, and then it came back before the commission December 1st, 2022. Commissioner O'Brien, I don't think that you were present for that meeting.
I was. So there was one that I wasn't able to go. That's why it sticks in my mind.
So that was the one, and it was the final vote. We had
The
received some
last
comments.
December one. Okay.
Right. And then because it was a racing regulation, there was that requirement that it needed to go to the legislature for 60 days. But ultimately, we ultimately held onto that reg and didn't file it. So it had gone through every single step of the promulgation process, but was never ultimately finalized. We took it back and then decided to create a much more robust racing framework beyond 2.01 and all the way through, I think now 2.07 for racing. And that's where we are today.
So on the suitability questions, I probably had the benefit of a year-long thinking about the 23N approach. Commissioner Skinner, to your point, I just have learned more about suitability and what we did under 23N and the temporary licensure process. And so I'm thinking about that process in light of 23K, very different process. 23N really did address the time frame of the sports wagering licensing process, and our regulations reflected that. So I appreciate and agree with Councilor Grossman's point that 23N is more likely a good guideline, but this is still, now that I know what I know, it is now quite different, and I'm just raising questions. And as long as we're all comfortable with the idea that the application could theoretically, we could have the benefit of the application being tweaked, after, because nobody applies, then we can tweak it once the regulation is passed. So I appreciate that, but I also know the theory is we're voting on this application today. So if in fact we had an applicant, would we all be comfortable? Because we would have to respond to it by November 15th. So I'm very aware of our time frame here. And again, last year, probably less appreciative of the 23N being in the background here, now that I know what I know. But this, we would be, without a reg in place, we would be using this as our roadmap, right? Todd, strictly this as our roadmap and the jurisprudence.
Yes.
So this is our time. If there's anything that sticks out to you as like, you want to clarify, and then one thing that jumped out at me was that language didn't seem to mirror exactly, but maybe it is exactly the language that it's used on seeking a notice of withdrawal. And then all of these items, I think you're right, Commissioner O'Brien, it reflects the BED, but I think we would be the decision makers under this. And the evaluator. Is that helpful, Commissioner Skinner? I might be completely wrong in the way I'm thinking, but this is, I've just had to get a little bit more comfortable because we are asking for suitability in a way that it is different through this application process. But I'm hearing today that the regs as proposed will mirror the 23N process. And that's new.
So Madam Chair, if I can, I just wanted to make sure I'm understanding you correctly. Are you asking if the process that's not necessarily captured in the application that will be enumerated in the regs is going to mirror what is demonstrated within 23N and echoed within the sports wagering regulation? So at which case the Bureau would complete an application, submit a written report to the commissioners, which would then include recommendations and those findings of fact relative to suitability of the applicant and qualifier, or for the new existing racing meeting licensee in this case. And then it would be in course the commission that would make that finding of suitability. Is that
That's not my question. I think I understand that. Right now, we don't have a reg, so we haven't discussed it, right? So we can't really guess it. But what I do understand by looking at the application, should we have to act on the application, that this process is set out to mirror what we, for instance, what a qualifier is under both the law and regulation under 23N. We spent a lot of time on those 5 factors or 6 factors, just recently. And then, of course, we just recently entertained a notice of withdrawal. So I wanted to make sure that that's clear, that the timing for that might be helpful and to understand that. And then otherwise, if all the answers are here in the application, right now, it would just be that we would be voting, we would be the decision makers. I think to your point and to Councilor Hall's earlier recommendation, that's for us to decide once we see the regulation unfold, right? Right, Todd? That's what I'm hearing is being right now imagined by our legal team. And I assume in coordination with IEB. But that's a pivot because we've had the benefit of 23N now the last year, which we didn't have. So that's why it's a little bit different, Commissioner Skinner, because it was approved last year right about this time when we were also erecting the 23N regs.
But in that approval, Madam Chair, the commission didn't charge itself with identifying qualifiers, right?
No, I don't.
That's always been left to IEB. And then, if there's a question as to whether designation of a qualifier is disputed, or, if it comes to the point where a petition for withdrawal is submitted, I think that's, if I understand you correctly, I think that's what you're more concerned with in terms of what the process is going to be, given the situation we just reviewed with an applicant for sports wagering. Is that, am I correct in that?
Well.
So I think it's apples and
I agree
oranges, I
with you
guess.
that- I agree with you that IEB has, I believe, deemed who's the qualifier, and that was actually a question that a commissioner raised to me on the last one. Why is it that we are now looking at whether or not someone is a qualifier? And that is because at a certain point, I understood our reg allowed them to come to the commission, or had to come to the commission, because of the timing of their request. Right?
Yeah, I get that. And so what
And
changed?
also on just who determines the qualifier, I think you're quite right. But again, I'm not sure if an application for horse racing, I don't want to belabor this, but I'm just saying, if there's any clarification as to where it's coming from, if we're following 23N somehow, or if we're following a practice that IEB should be making these determinations, and maybe we should just make that clear here in the application, and then have the reg follow. And I think I see Councillor Hall leaning in, and I don't know otherwise. Let's just imagine we do have some debate between an applicant about qualifier. Now that we just experienced that, so it's fresh in my mind. That's
Yeah, thanks, Chair. And obviously I'll defer to Judy and legal as well, but it looks like based on 5.1 subsection 5 and 6, there already is a provision in the application that specifically references the division of licensing after consultation with the IEB. So, I think that language is similar to what we have in regulation for the sports wagering applicants.
Where's the language about when they get to come to the commission?
That will probably, I'm assuming, will be in the reg, Chair. That if you're talking about the designation versus withdrawal request, that right now and what we just experienced was under 213. And it was 213.01 subsection 2 is why that the commission heard the withdrawal requests on the application that was just reviewed, because of it fell within that provision. Like you said, the timing of the application had come before the commission at the point when the 2 requests for withdrawal were filed.
Commissioners, if we want to continue on the review, that's fine. I don't know if you have any other further questions on suitability, or if you have any questions. Done. Want to go on to public interest then, section 6, Judy?
Absolutely. I'm sorry, I'm just toggling back to the application. Section 6 begins on page 35 of your packets, commissioners. Again, we make note of GLA, listen to me, I apologize, I haven't had breakfast. We make note of 128A, section 3I, in which case we still make notice of the interest of members of the public in race competition honestly managed and of good quality. Laying out specific questions, but nothing within section 6 was changed this time around. It is the same that was brought before you in July and again voted upon by the commission in June of 2022. I'm happy to answer any questions about those specific sections or questions within the section if you have any, though.
Questions, commissioners?
Okay. Moving on next to section 7 that begins on page 36 of your packets. This section was largely unchanged. I will note that we ask a brief question on question 7.3 that isn't necessarily a new question itself. However, we have asked that if the answer to the question, whether the premises of where the racing meeting is to be held are owned by the Commonwealth or any political subdivision, we've asked the licensee or prospective licensee, to submit an exhibit explaining that said ownership and their plans for either converting the ownership or taking full ownership of that land. So the question itself isn't new. However, the commission's request for more information surrounding the land ownership is kind of an added sub-question. If there are no additional ones, I can move on into section 8. I will just note that a large amount of kind of questions regarding the stable area that I think we had a few comments on are enumerated in section 7.7, subsection J. And then lastly, within section 8, in regard to wagering and simulcasting, we have added language from the updated 128C section 9 that went into effect on August 10th, stating that a running horse racing meeting shall conduct not less than 20 live racing days at a thoroughbred racing track. So just as a note, commissioners, that does kind of codify down to not harness racing applicants, if there were any that would fulfill or complete this application, but just thoroughbred racing applicants. And that is in question 8.2 on page 38 of your packets, enumerated in the second paragraph. This language was actually added. I do believe this language was added last year, if I'm not mistaken, in the fall after the promulgation of sports wagering. However, it didn't come into effect until August 10th of this year. Next, moving on into section 9, these are the general conditions and attestations that an applicant or potential applicant has to fulfill. Commissioner Hill, I think you asked a question earlier if there was a federal compliance requirement, and there is. On page 40, it is, I think, the third or fourth paragraph down. We ask that the applicant specifically comply with all federal, state, or local laws. So that language is there. And the next few pages, commissioners, leading up to the end of the meeting application, end of the meeting packet and racing application all the way through page 45 are just the affidavits that are signed by the applicant, depending on their corporate structure.
Judy, forgive me.
Yes.
Did we not ask about they're going to offer sports wagering?
We do. I apologize. I should have noted that one. It is within section. It's either section 7 or section 8, Madam Chair. Let me find the exact question.
Wagering and simulcasting. I feel like I've seen that, but I just am looking.
So we ask in 8.1 if they intend to offer account deposit wagering. I apologize. There is a specific question, in which case we ask about leased premises. That is new language that we've added, in which case they attempt to enter into contract to have another operator conduct sports wagering on the facility. Give me a second. I apologize. I should know this.
I believe it's 7.6. Is that right?
Yes. Fully for you, Commissioner.
It's
Yes,
only taken me 2 years to understand regulations.
it is question 7.6. I apologize. I'm not sure why it's not included in red line. But the full question, Madam Chair, on page 37 of the meeting packet and 13 of the application asks if the applicant anticipates leasing or renting any part of the premises to a third-party vendor or allowing any entity other than the licensee to operate any part of proposed premises, and then kind of codifies a list of catch-alls, including restaurants, entertainment, simulcasting, and a sports book. Thank you, Commissioner Hill. So the question is the same. However, we've added the mention of the sports book within 7.6. I apologize for not catching that red line.
Anything else, commissioners?
Any additional questions, commissioners, or comments or notes for myself or Dr. Lightbound? I think she is still here, but just likely off video. There she is.
Commissioners, I wonder if for transparency, if that 7.6, we do say simulcast operations as well in 7.6, but the sports book, if I recall our meeting out in Hardwick, the sports betting piece was a big piece of the local concern. Should we be adding a little bit more prominent, like section 8 is wagering simulcast? Should we also throw in sports wagering there, or no? Are we comfortable? Because it would be sports book. I get that that's about a third-party vendor, but we include simulcast operations. And when I went to section 8, because I was looking there too, Judy, I just wonder, just for transparency, or
A valid addition. We could simply, add in the mention of sports wagering and simulcasting in the section title, and then add a drop-down question after. I think, technically speaking, I would prefer doing it before, seeing as 8.1 discusses ADW wagering, then 8.2 sets out the statute in regard to simulcasting. So you could ask in the new section 8.1, does applicant intend to offer sports wagering as categorized under MGL Chapter 23N? I think it's a suitable question to ask.
it highlights it, right, in the same way, because they may have to have a vendor for simulcast, right? That's clear. And the same thing for sports book. What do you think, Commissioner Maynard?
No, that's, Madam Chair, I was thinking the same thing. It's kind of a nerdy theoretical legal argument, but theoretically, maybe they're offering their own sports book and they're not going to go with a vendor, or there are many different reasons to ask it. I would separate it out.
Absolutely.
Thanks.
Okay, so that will become the new section, or excuse me, commissioners, I apologize. That will become the new question 8.1, and then everything else will drop down and then kind of be added by section.
I think that's probably a good move. Anything else, commissioners? No, we're looking to move on this. Commissioners, you have no more questions, Joel? Are you prepared today to move on?
Madam Chair, I am ready to move on, and I'm actually ready to make a motion.
I'm ready to second you.
How do you know?
I know he's
what
gonna
the
do a
motion
great
is.
job.
You don't know what the motion is. Commissioner
Fair
O'Brien,
point, but I think I have a sneaking suspicion I know where he's going.
I think you're probably right. Okay, I'm not going to second guess you, Commissioner O'Brien. That was a pun. Commissioner Hill.
Madam Chair, I move that the commission approve the application for license to hold or conduct a new racing meeting as included in the commissioner's packet and discussed here today.
Second.
Okay, any questions or edits? Okay, Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard.
Aye.
I vote yes, 5-0. Thanks, everyone. We'll get that done. And we look forward to the regulations coming to us. Coming to us soon. That's right, Judy. Thank you. I
Thank you,
appreciate it.
commissioners.
I appreciate very much. Okay, thank you for your good work, Judy, and Dr. Lightbound. Thank you. And Commissioner Hill, I know you've been right there with them, so thank you. So now we turn to items 5 on our 5 and 6, actually, if you'll indulge me. We have 2 matters that we anticipate using the executive session for. And as you know, we have to have the chair speak, read into the record the open meeting law provision that applies. And one, of course, would be regarding a continuing conversation that we've had relevant to public safety matters generally. We've been getting updates. And in this case, a particular letter that we had asked to be crafted to MGM Resorts. And if we were to go in to executive session on that matter, this would apply. It would be that we would meet in executive session in accordance with general laws, chapter 30A, section 21A4, to discuss the use and deployment of security personnel or devices or strategies with respect thereto at gaming establishments. And we would vote on these separately. So with respect to that particular item on the agenda 5A, do I have a motion? Commissioner?
I think Commissioner Hill, were you moving? You were muted. I'll wait for you if you were moving. No? Okay. I move that the commission to go into executive session for the reasons and on the matter just stated by the chair.
Second.
Okay. Any discussion? Commissioner O'Brien?
Aye.
Commissioner Hill?
Aye.
Commissioner Skinner?
Aye.
And Commissioner Maynard?
Aye.
And I vote yes. So I believe that we would not be coming back into public session provided that we decide to on the next matter as well, that we could combine them. So at this point, a public session is not anticipated, but let's look at item number 6. So in that case, we would be getting an update from our legal team on particular litigation. Commission anticipates that it will meet in executive session in accordance with general laws, chapter 38, section 21A3, to discuss strategy with respect to Get Married versus WinMass LLC, as discussion in an open meeting may have a detrimental effect on the litigating position of the commission. Do I have a motion on that anticipated executive session? Does anybody want to go into executive session?
I can move again. I move that the commission go into executive session on the matter and for the reasons just stated by the chair.
Thank you. Have a second.
Second.
Thanks, Commissioner Hill. Commissioner O'Brien?
Aye.
Commissioner Hill?
Aye.
Commissioner Skinner?
Aye.
Commissioner Maynard?
Aye.
And I vote yes. So that's 5-0, and again, we would not anticipate coming back to public session because I think that we can move from one executive session into a second. I think, Grace, you confirmed that with Councilor Grossman. So with that, commissioners, Grace has provided a separate link for us to go into those executive sessions. Let's discuss lunch and everything once we get there. I know my questions to keep us, and my apologies for that. And then we'll not return to public session. We'll adjourn out of our executive session properly. So for the public, thank you for your attention. To the team members who are not joining the executive session, thank you for all your great work. I appreciate it. Right, so we'll go to our separate link, and it's in our email and in our calendar. Thank you.